Hi, I'm Debbie Moraes. Welcome once again to Legal Matters, the program that's been designed to address the relevant, critical, and sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. Once again, the program is sponsored by Bazar, Grasso law firm in East Providence, and we'd like to welcome once again Jackie Grasso to my left, and to her left, David Bazar. So today, ripped from the news, clipped from the websites or those gossip magazines, the legal risks and challenges and rights of sperm donors or egg donors. Actor Jason Patric's case has been a lightning rod of late, but certainly he's not the only one who's brought up these kinds of cases about custody. So there is existing law in some cases not. Is it custody? Is it contract law? What is the law? And what might actually come of some newly proposed laws? We thought this would be a good day, a good time for the critics and those who want to be parents have a chance to consider some of these topics before you embark or litigate, or there are quite a few surprises. So we've plenty to discuss. All right now, what is the situation? What is the law about, is it family law? What happens with egg and sperm donors?
Rhode Island doesn't have a law. Not surprisingly, there is no law on the books. Massachusetts does have a law, and it pertains to a married couple that decide to have artificial insemination. As long as the husband agrees that there be artificial insemination, any child born from that would be deemed the biological child of the husband. So he has paternal rights in Massachusetts.
Well, that's when it's very simple.
Correct, when it's simple, yeah.
So many wrinkles of late, so many wrinkles of late. And as I mentioned earlier, the Jason Patric case, he had a girlfriend. I guess the setup is he had a girlfriend. They decided to have a child, artificial insemination, and apparently he had signed, checked off that he was the intended parent, but that's in dispute now. And while he had initially acted as a parent, took care of the diaper changes and the evening feedings, the two are not together. He has been denied custody. He wants shared custody. What happens?
Well, so you talked about that, is it family law or is it contract law? Actually, it may start with property law in the beginning, because if you donate or bring sperm to a sperm bank of some nature, and it's, let's say, a couple that puts it away for themselves for the future and has it frozen, it's personal property at the start. When it becomes an embryo and a child, then family law is impacted. As Jackie was saying, in Massachusetts, if there's a married couple that has a child, there's a law in Massachusetts about the father being the father. In Rhode Island, there is a presumption. There's no statute on it, but there is a presumption that if a child, well, there actually might be a statute.
There's a presumption of paternity in both states.
There's a presumption that if a child's born during the marriage, that the father is the father of that child, subject to DNA testing and all sorts of other things that can be brought up.
The situation with Jason Patric, I think what happened is after he and his girlfriend broke up, he decided that he was going to donate his sperm, and at some point he signed some document that said he did not want to be the intended father. And then I believe later on, after the child was born, he developed a relationship with the child because they got back together and then they broke up again. And thus we are where we are today relative to this.
He's trying to promulgate a new law in the very liberal state of California, as we see it, that would mean that he would be able to have shared custody. There was initially, as I understood it, that there was a place where he checked off and said that he was the intended parent, and she wasn't opposed to that when they were together. And then there were subsequent letters.
After something changed. Yeah.
That changed.
Yeah.
So if they weren't married, is it still, David, a property right if you just decide to make a contract? You and I could make a contract.
It would be a contract right, and apparently not changing the initial contract, which was if he checked off that he intended to be the father, and then the child was born, it would seem that he would have the right to enforce that post their breakup, if that's what happened. They had a child and then broke up, so that he could enforce his parental rights as both being the biological father and by the contract of when he made the sperm donation to the sperm bank or the medical center or wherever it is that he brought it.
But go one step further, even if he loses on this case, on the contractual issue or being the biological, there is something called de facto parenting, where it's where the state or the court would recognize a parent or an individual who acts as a parent towards the child. If they have a long-term relationship, if this is the parent that the child has always known, the child refers to him as the father, then you have the de facto parenting issue that could come up. So maybe he could make that argument as well, because he does have a relationship with the child.
And that comes up in a number of different ways. In Rhode Island, there's a case that established de facto parenting, Patinato versus Patinato. And what happened in that case is the father had raised the child of the marriage for a number of years, until the teens, I believe.
Yeah, 14, I believe.
And then when the parties were getting divorced, the mother said, by the way, you're not the father. And DNA testing showed maybe he wasn't. But he had been the father for so long, the family court said he is the de facto father and gave him all the rights of any other father, and used all the best interest of the child standards and everything else that applies. So he, in fact, is the father by law in Rhode Island. So as Jackie is saying, in these situations where a child is born of a woman who was not married, in that case with the actor, but he raised the child for many years, that could be used in at least Rhode Island to establish a de facto parent relationship.
Address a couple of issues. So I believe Gus is the child's name. It's 2 years, and this man has been acting as father financially and doing the diaper changing. So if she has, and apparently she has some letters that she's flashed that said, he wrote to her and he said, I am really not prepared to be a father. Is that a reasonable ground? Is that a substantial thing for them to submit? I can't imagine any set of couples, even if they were in it together and planning to have a child, I can easily see someone saying, gee, I'm really not ready to have a father, to be a father.
Well, I think what was happening there is they're looking at the four corners of the contract, and they're saying, this is what you had initially intended, this is what's happening, and she's presenting that as evidence indicating, no, you indicated you did not want to be the parent subsequent to signing that contract. But now, he's acted as the parent, so there's evidence that he has taken on that fatherly role.
And wouldn't it be nice, perhaps, or not nice, but if all you had to do as a father or a mother is write a letter to your spouse and say, you know what, I was the dad for a while, but I'm not really ready to do this. It's just not how the law works.
The spirit of the law.
Quite surprisingly, it's the outcome. It's really unusual, because why would a court deny a child his or her parent?
Right.
And apparently there's some issue about whether or not he has even standing ground or legal standing ground to even bring this up. And I can't imagine that even, especially in a liberal state such as California, that they would even be going down this road. Of course he should be able to have this discussion and have the ability to man up.
Well, they're trying to change the law in California. He's trying to get the legislature to enact it.
Now, talk about it from another perspective, because I don't know the exact facts of this case, but there are sperm banks and donations made where they're done sort of anonymously. The medical center, the facility, keeps track of who the donors are and all of that. And when that is done, it's clearly done without the intent to be a parent. In fact, there's consideration usually paid for that. And you give up rights and you sign forms that say, nope, don't have any intent to be the father. I'm not going to be responsible for anything. I don't expect to have a relationship. Now, that person changes his mind and wants to follow the sperm, so to speak, to find the child, and now wants to establish rights and have a relationship for a child that he really had no intention in the beginning of having a relationship with. I can understand where a court might say, no, you can't do that, because the relationship that was created with the new father, if there is one, for the couple that had this child, would be infringed, and they can't expect someone to come back down the road and try to reach back in and take some kind of custody or relationship with somebody whom the agreement was there would never be a relationship.
Yes, clearly that would be upsetting. But, as you start to bring this up, and we should explore it, there are so many different combinations of parents these days, and I think on one hand, when we need to talk about, there's egg donors, we've been speaking about sperm donors, and if either one is doing this donation in the spirit of trying to help a couple who can't conceive, it should be a very rewarding experience, but clearly what we were talking about here is that it's now fraught with a lot of legal ramifications, other than just, I'm here, I'm doing this, and I'm signing off. And now apparently different states are coming back and saying not necessarily so. What's the story with an egg donor? If it's the egg donor who's expected to be the mother
Okay.
and carry the child, pretty clear.
So that's the biological mother.
Now you're talking, what happens with surrogacy?
Surrogacy is a different topic in and of itself, because first of all, you don't want to do that unless you have a written contract. So, and we can go way back to the Baby M case back in the early 80s, discuss that about, the pitfalls of surrogacy, because when somebody decides to be a surrogate, they are actually contracting just to carry that child, but they don't have any legal rights to the child, okay? And what's happened with that Baby M case way back in the 80s is the parent that carried that particular child had the child and decided, no, I changed my mind, now I want to be the mother of this child. And it wrangled all through the courts for years and years and years, and it was expensive to litigate that. And ultimately, I think what happened was the court let the child stay with the surrogate, if I remember that correctly.
And is there going to be more of that, because there are issues now where people decide, I think I'm changing my mind, and they have the right to do that even though they've signed on, as you said, as a contract. And I suppose we should bring up the issue. This should not be just a verbal contract between two people. It needs to be in writing, and I guess made law with lawyers. I mean,
Well,
legal and binding with lawyers.
If you go to your large law firms, they do have departments, believe it or not, that just handle surrogacy contracts.
Interesting.
Yeah, and I'm not 100% familiar with the Baby M case from back in the 80s, but it would seem today that if a person has contracted to carry through artificial insemination the child that was created by two other people, and there's a good solid contract that states this is what you're going to get paid, this is your consideration, and these are the rights that you have and these are the rights you give up, that would be enforceable. The more difficult situation would be one that Jackie can speak to more than I can, which is where somebody wants to be impregnated for their own baby and is asking the donor not to waive his rights as the father.
You're just talking about that inquiry I got in the office.
Yeah,
It's-
but in general, if you spoke
Certainly.
about how that works.
If you're going to have a sperm donor or an egg donor, make sure you go through a medical facility.
This is a very important point.
That is
Is
a
it
very
not?
facility, because then the court would deem that a true
Donor.
donor contract. What happened in my particular situation is I received an inquiry from an individual who wanted to have a baby, was single, and what I thought was to be getting a sperm from somebody that she knew a long time ago, and my understanding was this person was going to be a sperm donor. She wanted me to write up a contract that indicated that the donor would have no legal rights to the child, and that they would be, she would waive any and all rights towards child support. But what I found out later was that they were not going through a medical facility, and I absolutely refused to write that contract, because, I mean, look at, how can you walk away from having child support? You can't waive your right to child support. But in this particular situation, they weren't going through a medical facility, but they were doing it the traditional way.
Right.
Yes.
And then that was not something that I was going to be involved
Right.
with on the
In
legally.
a contract that's created based on the more traditional
Yeah.
insemination process would probably be void against public policy.
Oh, it would, yeah. You can't waive your right to supporting a child.
And apparently, from what I was researching for this, Pennsylvania and Ohio had cases where they talked about someone having the informal version of insemination, which is the more traditional way, which I found myself laughing, but apparently it's very hard, as you're saying, for them to make that a whole binding contract. So let's continue with this case that you were mentioning, and I have yet another one here where a single woman knew the donor, wanted to do it the traditional way. He agrees and he signs off, and they decide that they're going to have a contract, but then she loses her job, and now suddenly she said, uh-oh, I really do need some financial support here. Where's the court supposed to go with this? They've signed on, and as you said, rightly so, you wouldn't do it, you wouldn't honor it for that reason. Here's an example where someone said, wants to renegotiate it 2 years after the appearance of the child.
Well, I think the medical facility is important, and the fact that they didn't go through a medical facility is going to weigh heavily on the court. They're also going to look at the relationship between the parties, how well they knew one another, and the relationship with the father of the child, of the father and the child. And my impression would be that they would probably order child support in that situation.
The
'Cause
child
getting
support
back to
belongs
the
to the
public
child.
policy issue.
And the child is entitled to be supported by its mother and its father. So what they've in effect done is tried to contract away the rights of the unborn child. And unless they do it through the right process, it's not going to be enforceable.
So for people who are considering the donation process, they want to do the right thing, maybe not just for financial reasons, but want to do the right thing. The places where they are doing it medically supervised, as clinics or donor centers, we assume that they all have contracts that can be held up and will hold up in court. Do they also at that point still need to have a lawyer examine that contract if it's something that the facility is doing?
Not a bad idea.
Yeah, I mean, anytime anyone enters into a contract, I'd always want an attorney to review it for them, just to go through what it all means and what their rights are and what rights they're giving up.
Admittedly, a few years ago, before there were so many of these recombinations, many of which we haven't discussed as yet, it seemed that if you had just this contract, here it is, you're signing off, you're not the intended parent, you will not know who this person, who the impregnated person is, and that's it. That's the end of the story. But obviously, there have been additional chapters that have changed these wrinkles. When someone wants to be a surrogate, or someone wants to donate, do you think that there's real advantage in you not knowing, have it being an anonymous donor, rather than my good friend Joey down the street is wanting or willing? I mean, in one way, you might say, I know Joey down the street, he's got good genes, and
There's
there
a
are
relationship.
problems. Yes.
You have a relationship. Look at the relationship. I do recall reading a case, I don't know, a couple years ago. I was teaching one of my family law classes, and that example actually came up, where there wasn't a contract, the person was a sperm donor, there was a relationship between the two. They did it the traditional way without being medically supervised, and the court looked at the relationship between those two people, and they determined that, you know what, he is the father of the child, he's going to be responsible for supporting the child. There was no intention not to be a father in this situation.
Interesting. How about recently, there have been changes in the law about gay marriages. Two lesbians are together, maybe they weren't married, now they are married, they want to have a child, and in two scenarios, one, the brother of one of them is willing to donate the sperm. Here's the known donor. That contract is made, he signs off that he wants no connection to the child at all. The two who are together part. She now wants to have some coverage and some protection, have a male role model in her life. Does she have recourse since they've signed off, and it was done in the clinic, as I understand it? What happens now? How does that stand? And does it matter state to state?
Are you asking if the father of the child, the actual biological father, can come back or be brought back in?
Can he brought back in?
Well, if they went through the clinic and it was done appropriately and with the proper documentation, then I think he is pretty much safe and covered. The other issue would be whether or not the mom, who was not the carrying mom, the non-biological mother, would have rights, and how do you enforce those rights? So I would say in Rhode Island, they would be entitled to also bring an action in the divorce action as the de facto parent if that mom had been raising the child as well, and can enforce her parental rights.
So does that mean that you would have the man who was the real biological father now suddenly financially responsible, perhaps also on the scene, as well as the divorced mother? Will they both be held somehow accountable?
I think the dad is out. I
Out
think he
completely.
gets out because they followed the proper rules and have the proper contract and paperwork. He can't be brought back in just as if he were an anonymous sperm donor to a clinic and no one knew who he was. As long as they did it the right way and with the right paperwork. My concern would be for the mother who was not the biological mother, so that if she's raised the child for a number of years and has developed a relationship, that in the course of the divorce, the biological mother doesn't try to cut her out of the child's life. On the other hand, also can enforce the rights of the child for child support from that parent.
Well, yeah, one of the things the individual will be looking for is custody and support. It
Right.
would be just like a traditional divorce where the court would order both. Perhaps visitation, but in order to avoid that wrinkle there, if there is a same-sex couple that does, and one does have, carry the child, female carries the child, best way around that is for both parties, for the other party to adopt the child.
Although I do have one one query is, would the presumption that the child born of the marriage is a child of the marriage still?
That's a-
That
yeah.
would be interesting to see how the courts
Probably, yeah.
deal with that issue. But I would assume that for the sake of the child, that's something that you might start with.
So considering you're lawyers and you deal with law such as it is, and it seems to be a moving target or an evolving situation, you can speak to someone about what the current law is. Would you be in a position to be cautioning someone about the advantages or disadvantages or possible wrinkles, known sperm donor, not known sperm
Well, that's
donor?
exactly what I did in my particular case. And I had the person back in my office, and I explained to her, this is what you're giving up, and in good conscience, I don't think the court would enforce this contract. I just don't. You can't just walk away from your right to have support of a child. And they had a long-term, they actually had a short-term relation, but they didn't know each other. And I would not write up that contract. I advised against it. Where she went from there, I don't know.
Yeah, in fact, what they probably should have done is to go through the medical clinic and the medical paperwork that
I
goes
did
with
tell her to
that.
do that, yeah.
How about the oral agreement between two people? One where it's done in the clinic versus one where it's done traditional or the informal way. Is it more likely that in those cases there's going to be a different outcome when someone wants to have access to the child and responsibility for the child if he wants it, and someone decides to say later on, no, I really don't want that person in my life?
Well, I wouldn't think if you're going through a clinic that there would be an oral agreement. There would have
They
to
would
be a
make
written
sure.
contract.
Right.
They would be,
And so we would assume that all clinics would have such a contract?
yes,
Right.
yes.
Okay.
Yeah, and clearly to me, a written contract in the traditional way is pretty weak. An oral contract, I think, would be almost unenforceable.
And apparently in some states right now, even with the contract that's done between two people and not notarized, but certainly checked out by lawyers, apparently right now as it stands, there have been a number of cases that are being brought to court, and these things are being reviewed. What can you say to someone when they're coming to you for advice, when you can only speak to what the law is and certainly not what the law will be? How do you address that for clients? Do you just say, this is what it is, but you need to know that this
Yes,
is in
exactly.
flux and it may change?
Exactly. If there's been recent litigation on the issue, yes, exactly. We would inform them of
Yeah,
that.
there's a lot of areas of the law where things can change at any time.
Certainly.
It brings elder care advice to
Oh,
mind.
that
When
changes
people ask about
weekly.
Medicaid and what I need to do to qualify for help with a nursing home, and, there's
Tax law.
big changes in that often, and you can tell them, and I would tell them when I'm giving advice, as of today, this is what would happen. Now, when this comes up, the law may change, but you can only advise them on the status of the law as it exists at that time.
And
Let
in
me give
that
you-
state?
Let me give you an example of that. There was a case back in 2005 called Troxel versus Granville that basically said that grandparents have no rights as it
For
comes
visitation.
for visitation towards their children. In a nutshell, that's what it said. Now, somebody comes to my office, they want to file a grandparent visitation case, which you can still do in Rhode Island because our legislature has not changed the statute. Same thing in Massachusetts. And when somebody comes to our office, we have to advise them of that Supreme Court ruling, and the fact that the judge may not enforce your rights as a grandparent. So that's a risk that they have, and there are particular judges that may say, our United States Supreme Court has spoken, therefore you have no rights as a grandparent.
Of course, my argument on that would be that the United States Supreme Court really shouldn't be putting its nose into a state issue about how they want grandparents to be treated as regards to their children.
But that doesn't mean that they would be denied their rights or denied their right to due process. So I wouldn't discourage them from filing the case, but I also need to inform them that this is the law and this is a possibility.
That's right.
We can never guarantee anything in this business.
But as lawyers, you try to let people know as many different possible outcomes or anticipated scenarios that presumably they wouldn't know. Address this issue then. While we had in previous sessions talked about homosexual marriages and whether they were legal in one state and not another. So here we are, Mass, Rhode Island. One state's legal, another state it's not. Now that has changed. What happens with the situation where someone is coming to you and in the state where there is a law and you can share that law, you couldn't possibly anticipate that one of the two couples in the couple is likely to move to another state where the rules change or there aren't rules or it's in the process of. So how do you advise someone of that? Is that something that needs to even be addressed at this point? Because you couldn't know whether someone's going to move 2 years from now or break up 3 years from now.
Well, what happened was at a time when Rhode Island didn't have the Marriage Equality Act, and a couple moved from Massachusetts to Rhode Island and tried to file for a divorce in Rhode Island. It went to the Supreme Court, and our Supreme Court made a ruling that Rhode Island didn't have jurisdiction over that marriage because we didn't recognize the marriage, which was a totally erroneous ruling by our Supreme Court because it was an issue of jurisdiction. And you have to give full faith and credit to the laws of other states and recognize if it's a marriage in Massachusetts, even though they couldn't get married in Rhode Island, they're married, they're entitled to be divorced in Rhode Island. So you have to deal with those kind of situations. But it also raises the Marriage Equality Act. Another query this in my mind, people who got married under the civil union law in Rhode Island. Now, do they have to get remarried under the Marriage Equality Act, or if they continue to live together, and now that that block to being married has been removed, would common law marriage kick in?
Yeah, that's interesting.
It would be an interesting issue
Another
on that
topic.
level.
I think there was one other wrinkle that we needed to discuss, which was early on we were talking about when a couple gets together and decides to go to a clinic and have the artificial insemination. The couple that's married goes to a clinic and they decide to freeze his sperm only, A, maybe the scenario is that he passes away, or B, there's a divorce. So who owns that property then? What do you do with, what happens with that?
Well, with a divorce, you have to realize that that is property.
It's property.
Yes, it is a property. It's a property right, and you have to deal with it in the same way you would have to deal with this.
You can't divide it in half, Jackie.
No, you can't divide it in half, but you have to deal with it in divorce and determine, what is the intention between those people, and who has a right to that, and what's going to happen to it.
It would be my argument that the donor should be able to get back his donation, his property, because
Have it destroyed.
It was donated under a certain circumstance at the time that may no longer exist and no longer was intended for the use that it was originally donated for. On the death situation, you would argue they were married, the widow should inherit the property, and if she wants to use it, should have the right to be able to do that.
And would that be current law? Would that be or just a reasonable case that you could make?
That's the case that you would make.
Yeah, I agree.
This is such a complex issue. And I guess there are more wrinkles daily, as it seems. I hope that this has been helpful to you. It's certainly a multifaceted, complex issue. Thank you for sharing the information, Jackie and David. We once again thank the law firm, and we hope that you will stay tuned as our discussion of legal matters continues.